Welcome to today's deep dive. We are really thrilled to have you here with us.
Yeah, thanks for having me. It's an exciting one.
Today, we are unpacking a really fascinating and, well, a highly specific legal problem that touches on the very edges of our modern industrial society.
Absolutely.
Imagine a massive, bustling manufacturing plant, and in the blink of an eye, a catastrophic, toxic chemical reaction occurs. The consequences are devastating, lives are forever altered.
Right.
We are looking at a crucial question for you to understand today. When a company engages in an activity so inherently dangerous that things go catastrophically wrong, when exactly are they held strictly liable, regardless of whether they were actually at fault?
Exactly. And the analytical path we're taking today will guide you through the doctrine of what the law calls ultra-hazardous or abnormally dangerous activities.
Okay.
We're going to dissect the strict liability principles that originally stem from the historic 1868 English case of Rylance v. Fletcher.
Right, the class.
From there, we will bridge the gap to modern law and apply the definitive six-factor test found in sections 519 and 520 of the Restatement Second of Torts.
Got it.
By the end of this deep dive, you will have a comprehensive framework to understand exactly how courts weigh these incredibly complex high-stakes scenarios.
Okay, before we get into the modern plumbing disasters and toxic chemicals, I want to go back to that origin point you just mentioned.
Yeah.
You promised us the 1868 case of Rylance v. Fletcher. Why did the court suddenly decide they needed a whole new category of liability where, fault didn't even matter?
It is a brilliant story, and it provides the absolute foundation for everything we will discuss today. So in 1860s England, John Rylance was this wealthy mill owner who wanted to build a large reservoir on his land to supply water to his mill.
Makes sense.
Next door, Thomas Fletcher operated an active working coal mine. What Rylance didn't know, and what the independent engineers he hired didn't notice, was that underneath his new reservoir were abandoned, centuries-old coal shafts that connected directly to Fletcher's active mine.
Oh, boy. I can see where this is going, and it doesn't sound good for the miners.
It was disastrous. Shortly after the reservoir was filled, the immense weight and pressure of the water broke through the ground, flooded down into those old, forgotten shafts, and completely inundated Fletcher's active coal mine. Wow. Ruined his business completely. Now, Fletcher sued Rylance, but under the law at the time, to win, Fletcher had to prove Rylance was negligent.
Right, that's the standard.
The problem was, Rylance wasn't negligent. He had hired competent engineers. He had no idea the old shafts were there. He exercised reasonable care.
But it feels deeply unfair that Fletcher just loses his entire livelihood because of his neighbor's massive water project, right?
The House of Lords completely agreed. They realized the traditional negligence framework was just inadequate for massive, unnatural risks. So they created a new rule.
Oh, was it?
The court famously declared that the person who, for his own purposes, brings on his land and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril.
At his peril.
Right. If he does not do so, he is prima facie answerable for all the damage, which is the natural consequence of its escape. That was the birth of strict liability for abnormally dangerous activities.
So if you bring a massive unnatural hazard into the world, you pay for the damage it causes, period.
Exactly. Fault is irrelevant.
So let's unpack how we get from flooded coal mines in the 1860s to modern law. What exactly transforms a standard, everyday business operation into an ultra-hazardous activity in the eyes of the modern legal system?
To answer that, we look to the Restatement Second of Torts. You can think of the Restatement as a massive, highly respected encyclopedia that synthesizes and summarizes the common law for judges and lawyers across the country.
Okay.
The general rule from the Restatement is this: an activity is considered ultra-hazardous or abnormally dangerous if it necessarily involves a risk of serious harm to the person, land, or chattels of others. And just to clarify the jargon, chattels is simply the traditional legal term for personal property, like your car or your equipment.
Got it. So risk of serious harm to people, land, or property.
Exactly.
Yeah.
But it must be a risk that simply cannot be eliminated by the exercise of the utmost care, and it must not be a matter of common usage.
Okay.
Crucially, determining whether an activity fits this definition is a question of law. That means it is for the court, the judge, to decide, not a jury.
Interesting.
To make this determination, the court relies on 6 distinct factors outlined in Section 520 of the Restatement, which must be considered and balanced together.
Let's apply this to our foundational case for this deep dive. Let's analyze Edwards v. Post Transportation Company. First, what are the legally dispositive facts?
Here is what happened. The plaintiff, Charles Edwards, worked for Norris Industries, a company that manufactured zinc-plated cartridge cases.
Okay.
Norris decided to build a brand new waste treatment facility to dispose of toxic emulsions from their plating plant. This new facility included two large, interchangeable storage tanks. One tank was meant for sodium bisulfite, which, because of its chemical properties, requires plastic pipes.
Gotcha.
The other tank is meant for sulfuric acid, which requires stainless steel pipes.
So they had a very specific engineering requirement for these dangerous chemicals.
They did, but they completely botched it. Due to a massive construction error by the contractors, the pipes were switched.
You're kidding.
No, the plastic pipe was physically hooked to the sulfuric acid tank, and the stainless steel pipe was hooked to the sodium bisulfate tank. When Norris Industries realized this, they had a choice. Spend the time and money to rip out the plumbing and fix the pipes, or take the easy way out.
Let me guess.
They took the easy way out. They simply swapped the identity of the interchangeable tanks, but they inadequately labeled them. The labels were small, confusing, and not clearly visible from the delivery intake valves.
That is building an absolute trap for whoever has to deliver those chemicals.
Precisely. Later, the defendant, a driver for Post Transportation Company, arrived to deliver a massive tank truck of highly concentrated sulfuric acid. Because of the poor labeling and the confusing pipe setup, the driver was directed by Norris employees to pump the sulfuric acid into the wrong pipe. Yeah, it traveled through the system and poured directly into the sodium bisulfite tank.
And what happens when those two chemicals mix?
A severe, immediate, and violent chemical reaction. The sodium bisulfite tank contained a residue of the chemical mixed with water. The moment the sulfuric acid hit it, it created a massive, erupting cloud of toxic hydrogen sulfide gas.
That is terrifying.
It really is. The plaintiff, Charles Edwards, was just working his normal shift in an adjacent part of the Norris plant. He was completely overcome by the toxic gas cloud and suffered severe permanent injuries to his respiratory system.
So why didn't he just sue Norris Industries?
Because of workers' compensation laws, Edwards was legally barred from suing his own employer, Norris, for a traditional tort. He was trapped. So he looked for another party to hold responsible. He sued Post Transportation, the delivery company, under common law, claiming strict liability based on them engaging in an ultra-hazardous activity.
And what was the core legal issue?
The precise legal issue is this: whether, under these factual circumstances, Post Transportation's delivery and handling of sulfuric acid constitutes an ultra-hazardous activity, thereby subjecting them to strict liability.
I want to get into the mechanics of how the judge actually decided this. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule from the Restatement Second of Torts, Section 520. We will analyze this using a mini IRAC structure, which is just our standard issue, rule, application, and conclusion framework that courts use to methodically break down a problem.
Okay, lay it out for us.
The black-letter rule dictates that an activity is abnormally dangerous if it meets a balancing test of 6 distinct elements or factors which must be considered together.
Go on.
First, the existence of a high degree of risk of some harm to the person, land, or chattels of others. Second, the likelihood that the harm resulting from it will be great. Third, the inability to eliminate the risk by the exercise of reasonable care. Fourth, the extent to which the activity is not a matter of common usage. Fifth, the inappropriateness of the activity to the place where it is carried on. And sixth, the extent to which its value to the community is outweighed by its dangerous attributes.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the existence of a high degree of risk?
We start our first mini IRAC right here. The sub-issue is, does sulfuric acid inherently pose a high degree of risk? The sub-rule requires that the substance must be inherently hazardous in its very nature.
And what did the facts show?
In its application, the court looked closely at the expert testimony. The experts testified that this chemical is highly reactive. It rapidly attacks most materials, including metals and plastics, and it is heavily regulated and governmentally listed as a hazardous material.
So it's basically undisputed.
Correct. Therefore, the conclusion is that this first element is met. There is undeniably a severe high degree of risk involved in transporting it.
That makes total sense. The chemical itself is undeniably brutal. But we have to look at the consequences of that chemical actually getting loose. Understood. Now, what about the second element, the likelihood that the resulting harm will be great?
Our next mini IRAC looks at the fallout. The sub-issue is, if an exposure event actually occurs, is the harm exceptionally severe.
Right.
The sub-rule dictates that the potential damage to a person or property must be significant and widespread, not minor. For the application, the court again relied on the scientific experts, who confirmed that the resulting toxic hydrogen sulfide gas creates severe chemical burns.
Just awful.
It actively attacks and destroys any human respiratory tissue it touches, often causing permanent disability or death. The conclusion is clear: the element is met. If an accident happens, the resulting harm to humans is highly likely to be incredibly great.
It is genuinely terrifying to picture that kind of exposure just from being at work. But here is where I get hung up. If everyone knows it is so dangerous, shouldn't they just be extra careful? How does the court view the ability to actually mitigate that danger? Understood. Now, what about the third element, the inability to eliminate the risk by the exercise of reasonable care?
This is exactly where the case pivots. This is the most crucial mini-IRAC of the entire analysis.
Right.
The sub-issue is, can the extreme danger of sulfuric acid be mitigated or neutralized through proper procedures?
And the rule.
The sub-rule states that if ordinary reasonable care makes the activity safe, then strict liability does not apply. Instead, you're just relying on standard negligence. In applying the facts, the court noted something completely fascinating.
What was that?
The very same scientific experts who called the chemical highly dangerous universally agreed that if sulfuric acid is handled in a proper fashion, there is, quote, no danger.
No danger at all.
None. Transporters undergo special training, they use specialized double-walled trucks, and they have specialized registration designed specifically to eliminate these special risks. If you just hook the hose to the right pipe, nothing happens.
Wow.
So the conclusion is that this element is not met. The risk absolutely can be eliminated through the exercise of reasonable care.
Right. So just knowing how to properly handle it changes the game entirely. But let's look at who is actually handling this stuff in the real world. For instance, driving a car at 70 miles an hour is incredibly dangerous and causes thousands of injuries, but because everyone does it, it's not considered ultra-hazardous. But nobody is keeping a vat of concentrated sulfuric acid in their residential garage. Understood. Now, what about the fourth element, the extent to which the activity is not a matter of common usage?
That is the perfect analogy. For this mini-IRAC, the sub-issue is sulfuric acid usage common among the general public? The sub-rule states that the activity must not be widely accepted and carried on by a large percentage of the population, exactly like driving an automobile.
So how do they apply that?
In application, the court found that while sulfuric acid is a staple, regular resource used in certain specific heavy chemical industries, it is certainly not utilized by the general public in their everyday lives or ordinary commerce.
Makes sense.
So the conclusion is that this element is met, and it weighs in the plaintiff's favor.
So it is definitely an uncommon, highly specialized industrial activity. But does where they were doing it matter to the court's balancing test? Understood. Now, what about the fifth element, the inappropriateness of the activity to the place where it is carried on?
Location is vital. The sub-issue here was a modern manufacturing plant, an inappropriate place for this chemical to be delivered. The sub-rule requires the location to be fundamentally unsuited for the danger.
Like what?
For instance, if you were drilling a commercial high-pressure oil well in the middle of a quiet residential neighborhood, that is completely inappropriate.
Got it.
Applying this to our facts, the court determined that the use of heavy chemicals in a modern industrially zoned manufacturing plant like Norris Industries is an activity that is reasonably to be expected in that specific environment. That is exactly what industrial parks are built for.
Right.
Therefore, the conclusion is that this element is not met, or at least deemed not of significant importance, so it weighs against the plaintiff.
That is logical. You expect heavy, dangerous chemicals in a factory district, not a suburb. Finally, we have to look at the big picture of why we even tolerate the use of this stuff in society at all. Understood. Now, what about the sixth element, the extent to which its value to the community is outweighed by its dangerous attributes?
Our final mini-IROC tackles public policy. The sub-issue is, do the dangerous attributes of sulfuric acid override its overall utility to society?
Okay.
The sub-rule is that if the substance isn't strictly necessary or highly beneficial to society, strict liability might be applied much more readily to protect innocent victims.
And sulfuric acid is pretty useful, right?
Extremely. Applying this, the court acknowledged that sulfuric acid is unquestionably beneficial. It is one of the most widely used chemicals in all of modern manufacturing, foundational to countless products. However, The court decided it is not so fundamentally necessary to the survival of society that the law should completely insulate its users from strict liability if the other factors demanded it. Thus, the conclusion is that this element is met, and it slightly weighs in the plaintiff's favor.
So we have a complex mix of factors, some weighing heavily for the plaintiff, some weighing heavily for the defense. And after analyzing all the elements, what was the court's final conclusion?
The ultimate holding was a defense verdict, which the appellate court firmly affirmed. Because these 6 factors from the restatement must be weighed together in balance, the court concluded that strict liability does not apply to the transportation and handling of sulfuric acid.
So post-transportation is off the hook for strict liability.
Yes, the absolute linchpin of their reasoning was that third element, because the danger of sulfuric acid can be mathematically eliminated through the use of reasonable care, like simply pumping it into the correct, properly labeled pipe. Ordinary rules of fault and negligence are entirely sufficient to allocate the risk.
So if it goes wrong, someone was just negligent.
Exactly. If damage happens, it is definitionally the result of someone's negligence, like the terrible, inadequate labeling by Norris or a failure by the driver to verify the intake. Therefore, there is no public policy need to impose liability without fault. If it can be made safe, you have to prove who made it unsafe.
I want to transition to a visceral hypothetical for you, the listener, to help permanently memorize this crucial third element. Remember, this is the element regarding the inability to eliminate risk with reasonable care. Imagine a company is transporting genetically modified, hyper-aggressive, acid-spitting murder hornets in glass jars through a crowded city.
That is a completely terrifying but absolutely perfect hypothetical for this rule. Let's break that down. With those genetically modified murder hornets, no amount of reasonable care, no matter how incredibly thick those glass jars are, no matter how carefully the driver navigates the city streets, no matter how much specialized training the handlers have,
Yeah.
can eliminate the catastrophic risk if a random, unavoidable traffic accident occurs.
Right, a truck runs a red light and hits them.
And those jars break. The risk is inherent, it has a mind of its own, and it is entirely uneliminatable. That is classic, textbook, strict liability, just like the flooding water in Rylands.
So contrast that for us with the acid.
Contrast this vividly with the Edward sulfuric acid case. A giant vat of toxic acid is terrifying, yes, but the acid doesn't want to escape. If you simply hook the hose up and pump it into the correct stainless steel pipe, nothing bad happens. Proper care mathematically eliminates the danger entirely.
So what does this all mean for how you, our listener, should approach these types of problems moving forward?
To synthesize this entire deep dive into a step-by-step diagnostic checklist for you, designed specifically as an exam-taking tool for issue spotting and structured analysis, here's how you should approach any fact pattern involving a massive disaster.
Let's hear the checklist.
Step 1. Identify if the plaintiff suffered an injury from a hazardous activity conducted by the defendant.
Okay, basic injury and cause.
Step 2. Determine if the plaintiff is barred from a standard negligence claim. For example, are there workers' compensation issues, as we saw with Edwards being barred from suing his employer Norris? Or does the plaintiff simply lack proof of fault, pushing your analysis to evaluate strict liability?
Makes sense. What's next?
Step 3. Apply the Restatement Section 520 balancing test. Do not just stop at asking, is it dangerous? You must methodically weigh all 6 factors: high risk, great harm, inability to eliminate risk with care, uncommon usage, inappropriate location, and value outweighed by danger. Perform a mini IRAC for each.
And the final step?
Step 4, and this is the clincher. Isolate factor C. Ask yourself, can a reasonably careful person make this activity 100% safe? If the answer is yes, strict liability for an ultra-hazardous activity likely fails, and you must proceed under standard negligence rules.
I want to leave you with a final provocative thought to mull over. If strict liability hinges so heavily on human inability to eliminate risk with care, what happens in the near future?
That's a great question.
Imagine a world where advanced AI and fully automated robotic handlers can theoretically exercise perfect care with every dangerous substance. No dropped containers, no misread labels, no human error of crossing the plastic and stainless steel pipes.
It changes everything.
Will the doctrine of ultra-hazardous activity completely cease to exist because technology makes every single risk technically eliminatable? It's a fascinating evolution of the law to ponder as you review your notes. Thank you for joining us on this deep dive.